Okay, we call to order this meeting, July 15, 2015, and pledge allegiance. I pledge allegiance to the flag of the United States of America,
to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Michael, roll call noted. Okay. Usually the first 3 minutes, someone's talk about a topic that's not in the agenda. We open up the public comment for anybody. Okay, we close public comment. The consent agenda. Anybody have any questions? Council, commissioners? No.
Mr. Chair, if there's no comments, then I'll make a motion to approve the consent calendar. Second.
All in favor?
Aye.
So the regular agenda continues from last
I'll go ahead
meeting
and kick it off and turn it over to you.
on the lot line adjustment. Do we have some?
We continued this item from last meeting so that Barbara could be here, our legal counsel who's working on this case. So I'll go ahead and let Barbara handle it.
Okay, at issue today is whether the Planning Commission wished to schedule the appeal of a lot line adjustment and certificate of compliance that happened in 2007. We're actually not hearing the appeal today. It's on for a recommendation that you dismiss the request for appeal as untimely. Let me get a little bit into the background. In 2007, there was a lot line adjustment and a certificate of compliance, and the surveys that were submitted as part of that line adjustment adjusted the northern border between the parcel that was owned by the person that was going through the lot line adjustment and Mrs. Lovelace's property. And it resulted, the new survey resulted in the boundary being moved, and which had less takeaway property from Mrs. Lovelace. The survey line actually moved a little bit. Well, it moved significantly. When we looked at this issue, and then I've talked to the Public Works Department about surveys, the first thing I wanted to call the Planning Commission's attention to is that the surveyor has a professional responsibility to do a thorough investigation before they actually file a survey map. You can tell in the document that I passed out today that they actually considered the issue because they have two different number of feet. And on the documents of the time, it notes that there is both an iron marker without a tag, and then there was an iron marker with a tag. And the new survey uses the iron marker with the tag. And the surveyor considered that and determined that the proper boundary was the one that he indicated in his survey. At this point in time, there's no evidence indicating that that survey was incorrect. In addition, in some of the documents that were submitted just today, it indicates that there was also a previous survey. It's an ALTA survey, which may not be quite as comprehensive, but they use that as a support for the issue that there was this discrepancy or difference of opinion about where the boundary should be. So the surveyor, when they were doing the survey map, came to his professional conclusion about what he thought the proper boundary line was, and that was what he submitted to the county. When the county reviews it, they do an overall review of the survey map, but they don't actually go out on site to do a complete survey, looking at the site, looking at all the documents. They rely on the surveyor as they submit the documents to make sure that they have a survey that's accurate and professionally complete. So that was approved. Now, there's a lot of issues that are going on with this case. We have to distinguish between a statute of limitations that would apply if this matter was brought in court, and there could be a number of causes of action that were brought, and the other issue about whether the Planning Commission has the authority here at this point in time. An appeal of an administrative decision can go to the Planning Commission within 10 days, It's undisputed that it's been more than 10 days since the decision was made in 2007. It's also been far more than 10 days since it came to the attention of the Lovelaces, because it was known between January and I think April of 2014, which was last year, that this issue existed, and there was no appeal filed right after it came to their attention. So I think that the county does not have the authority for the Planning Commission to hear this. Plus, there's been no evidence that the survey was incorrect. At best, if another surveyor came with a survey that indicated that it was incorrect, now you're going to have a competing differences of professional opinion between two surveyors. So you have that issue that's going to have to be weighed by a court, and then you have other issues, whether or not the Lovelaces could have a cause for adverse possession if they've treated that property as their own for the requisite period of time. So there's a number of issues here, and I just recommend that the Planning Commission just deny this and let the parties resolve this without it going to the Planning Commission, which is going to probably make things more convoluted than they need to be, and I just don't know that there's authority for the Planning Commission to hear it at this point in time. But I'm open for any questions.
Commissioners?
And both parties are here today as well. And another thing that kind of complicates the matter is that the property was sold after the lot line adjustment and the certificate of compliance occurred. Now, the property that it was sold to, the current owner was involved with the lot line transaction, but it actually isn't a purchaser that bought the property after the lot line adjustment occurred. So you have a new purchaser of the property. It's not even the same parties that were present in 2007. And the neighboring property owner has just submitted a letter today also indicating that they don't believe that the Planning Commission has the authority to hear the matter, and they feel that they would have damages if the lot line adjustment was overturned at this point in time as well. So you have both parties that have indicated that, that there may be some potential damages in this matter, and it will remain to be seen about whether that survey was correct or incorrect at the time, but that's going to have to be weighed out probably in court.
Commissioners, any questions?
I have a few comments, but I'll reserve them to the planning commissioner comments portion after public comment.
Is there someone here from the other party, from the Loveless party? Yes, our public comment is open.
My name is Donna Bakich. I'm the attorney of record for Ms. Loveless in this matter. I'm also the author of the appeal letter dated May 21st, which I believe is in your records. Just a couple points of clarification. My letter states that Ms. Loveless didn't receive actual notice, any type of notice, until well after January 2014. She only had reason to look into the matter because Mr. Franchione was on her property claiming that he had the right to build a fence on 3 acres of property that my client recognized for the life of her to belong to her.
Can I repeat right there?
Yes.
So what was the date that your client noticed that?
My client didn't receive actual notice until sometime in May 2014.
But we're July 2015 now.
Right. And in June, within days of learning that there was a 2007 lot line adjustment approved by the county, she met with Byron the planning director, who told her that she explained to him she'd never been notified of the lot line adjustment, and he confirmed that after checking his records. He also told her that he would have to talk to county council and the planning commission. He never informed her of any appeal process or any need to submit anything in writing, and just continued to stall the matter until November 2014, when my client proactively got somebody else involved to nudge Byron into the right direction, at which point she heard from Barbara. So there was this exact issue, the 2007 lot line adjustment, did come to the county's attention within a matter of days from my client seeing the 2007 lot line adjustment approval and understanding that it was approved.
But yet no appeal is filed.
Not until May of this year, only because my client was not informed at the time unrepresented that she needed to submit anything in writing.
What?
She brought this to the attention of Byron.
I thought Pipo represented her in March 2014.
He did, as to litigation, he represented her specifically with regards to a lot line, to lot swap, a land swap unrelated that Mr. Francione was recommending she enter into or else he was going to sue her.
Okay, but you said that she found out about a problem with the lot line in January 2014. In March,
She actually found him on her property and started looking into the matter.
in January.
Mr. Francione, through counsel, I believe it was Paul Moncrief, submitted letters stating that he wanted to swap property unrelated to this property, this 3 acres. He wanted to swap property for a road to access another lot that he leases near my client's property. And so she was represented by Mr. Piper with regards to that threat of litigation. It wasn't until May of 2014 that she actually saw the 2007 lot line adjustment approval.
May 2014?
2014. And within days reported this discovery to Byron, who started looking into it. So she didn't submit an appeal in writing, she submitted it orally to the director of the planning department and wasn't told at that time that she needed to file something in writing.
Okay.
And to be honest, when I met with Byron Turner in April of this year and asked him how we were supposed to go about appealing this very unique situation, I was not told to submit an appeal in writing. I offered that and asked if there was any certain format for an appeal, if there was a form to fill out, or if I just did it by way of a letter.
Okay.
So I don't believe that the county should be allowed to drag their feet, not inform my client that she should be filing a written appeal when she discovers something along these lines, and now hide behind a 10-day statute of limitations or a 90-day statute of limitations in order to be able to appeal this.
And if we were talking about a month or a week or two, you might have something to go on, but we are now middle of July 2015. And I know your letter of appeal was dated May 2015. That's a full year after, a year and something after Pipel's representation in March of 2014. And I think it's safe to say that she was represented by a licensed California attorney during the early spring of 2014.
But like I said, the scope of representation need not include the 2007 lot line approval.
Okay.
The threat of litigation from an unaffected area.
Right. So I interrupted you. Go ahead. I know it's like the Court of Appeal, right?
Right.
Like moot court?
I welcome your As it stands, my client has retained a surveyor and is looking into a professional opinion. And all we request is the opportunity to be able to bring facts to the attention of the planning commission.
Any questions, commissioners?
I asked all mine.
Uh-huh.
Thank you.
Anybody else speak on this matter?
Good evening. My name is Dennis Lewis. I represent Ray Francione, who owns a parcel of property that adjoins the Loveless property to the north. There's two issues here. There's a request to appeal the approval of a certificate of compliance, and there's a request to approve the approval of the lot line adjustment. I submitted a letter today to Barbara Thompson and requested that letter be filed with you guys for the record. And it goes into detail, maybe a little too much detail about the statute of limitations.
We all received the letter via email, and then she passed out a copy.
Okay.
As well.
So I'll just touch on the primary points, and if you guys have questions, feel free to ask them. But when it comes to the certificate of compliance, the Subdivision Map Act applies, and that's a 90-day statute of limitation. And it's not just a statute of limitations, it's a statute of repose. That means that you have to file the appeal within 90 days, no matter what the circumstances is. There is no delayed discovery rule, there's nothing like that. So the fact that she didn't get notice, if that's true at all, that's not relevant. It's a statute of repose, which means once the 90-day period is up, you're done. It doesn't matter what the reason was for you not filing a timely appeal. Now, for the lot line adjustment, the 10-day period set forth in the San Benito County Code 25.47 would apply. And that provides for a 10-day statute of limitations. Now, there's an issue of whether or not the delayed discovery rule would apply, and that basically means when the statute of limitations begins to run on the accrual of a cause of action, which means when somebody knows facts that they have been harmed. But there's certain situations where the courts will say, you know what, it's not fair to impose that. But what those decisions say is that once you have facts giving you notice that you have been harmed, you have to file the appeal. So here, by Ms. Backage's own admission, she knew, Ms. Lovelace was on actual notice of the approval of the lot line adjustment in May of 2014. The request for the appeal was not made until May of 2015. Citizens are presumed to know the law, especially citizens who are represented by counsel. So the fact that she was not expressly told, if it's true, that you had to file an appeal is not relevant. The statute of limitations began to run on the lot line approval as soon as she knew about it. And by her own admission, she knew about it in May of 2014. So no matter what way you want to slice it, the request is time barred. And that's all I have to say. Thank you.
Any questions? Anybody else?
And there, go ahead.
Barbara, so the only thing I could see would be upon discovery, but I'm not an attorney.
Well, even
So
upon
can you actually address both of those and kind of give us some help here?
Well, in the March 20th, 2014 letter, if you turn to the exhibits attached to this letter, it does indicate that it talks about the survey. It talks about the letter from Pipel, which is Lovelace's attorney, says the survey your client conducted ignores the 1974 survey. So they knew that the survey that was done for the lot line adjustment and the certificate of compliance was done in March. And then there's a reply letter back in April 23rd of 2014 indicates that, that survey ignores a different survey that was done for Granite Rock in 1988. And so there's this discussion from March 20th at least on that shows knowledge of the survey. So in my mind, it's undisputed that they knew about it for far more than the 10 days that our code allows. And so I do believe it's time barred. It doesn't mean that they may be completely without remedy, because there's a different statute of limitations if the survey turns out to be incorrect, that they perhaps could go against the surveyor. But that presumes that the survey is actually incorrect. So there may be some remedy, and there may be even some remedy in court, because they're going to have to battle out that statute of limitations in court. But what it's not, doesn't need to go to is the Planning Commission. And even if the Planning Commission heard the issue and reversed the lot line adjustment, hypothetically, you're still going to have another party that would challenge that and potentially bring litigation. So there's no action the Planning Commission really can take that's going to make the parties come to a mutual agreement on this issue and resolve it and have it go away. It doesn't seem like there's a remedy that the Planning Commission that can reasonably take in this situation to resolve it.
And it would seem like at least bare minimum, we would need at least an engineer from the other side to come in and contest, if that is even possible, the actual first engineer. Otherwise, you have to assume that, an engineer is giving you correct factual information, right?
Yes, there's nothing so far to indicate that the survey is incorrect. It was a professional judgment by that surveyor, which was different than a prior survey, but the surveyor knew about the prior survey and still moved that line to adjust what he thought was his professional opinion about where that where the boundary line should be. And I think that it clouds the issue to have the Planning Commission take it up at this point in time. It adds another layer of complexity to it that is not going to resolve the situation.
Seems like it's outside of our jurisdiction.
And just outside of the jurisdiction, there's no grounds to, on just the timeliness factor, there's no grounds to hear it.
Yeah.
Do we have any more questions?
Public comment.
Public comment is closed. Commissioners, what is your wish?
Yeah, one of the reasons we continued this from last time was to give me an opportunity to speak with Barbara about this issue from a legal standpoint, and I did that. And I think that's, I agree with the conclusion that it is jurisdictional, meaning that if we don't have the ability to consider this, then it doesn't matter what the merits are about the survey being wrong, right, pipes, tags, any of that stuff. You either have the ability to be before a decision maker or you don't. And with this matter, I don't see that it's even that determinative as to whether it's March 2014 or January or May. I mean, any of those dates are a full year ago. And therefore, even if you adopt a 90-day statute of repose or a 10-day county ordinance, we're way past that. So unfortunately, had an appeal been timely filed or even brought at the time that this was first brought to the attention of Ms. Lovelace, that would be a different question. But at this point, and I guess we would use the date of the appeal, May of 2015, not tonight's date. But the date that the appeal was filed in May of 2015, I think that's far outside of any opportunity for this commission as a body to consider this. So, as County Council's indicated, perhaps there's redress in Superior Court, other causes of action, but as to this appeal, I have concluded that it does not lie. That's my feeling.
Any,
You want to make a motion?
I'd-
You need to make a
you want to make a motion?
Sure, I'd make a motion that the appeal filed by Ms. Lovelace and her counsel is respectfully denied.
All in favor?
second that first.
Oh, sorry.
Rejected as untimely?
Correct.
Second. All in favor?
Aye.
Aye.
And for the record, I'd like to also point out for the minutes that we did not get to the merits and are not making any opinion or have not commented upon, reviewed, or considered the merits of the matter whatsoever. It's purely a procedural issue.
So we had all in favor?
I'll amend the motion, so is there a second to that one?
I'll second that one if you want to.
Okay.
All in favor?
Aye.
Aye.
Aye. Next item. Number 4 and 5 are together, Byron?
Is that the next item?
Or the-
I got my,
the use permit, sorry.
yeah, I've got use permit number 1115-15 for the McKinseys. It's located at 1301 Nash Road. The applicant is proposing to install a 1,000 square foot accessory senior dwelling unit located approximately 180 feet from the property's main residence. An existing driveway with a new septic system and new utility connections would serve the residents. As you know, locating within over 100 feet from the main dwelling requires approval of the Planning Commission, typically staff. This is a staff approval level. The reason for the request for the distance is due to the floodplain, which limits the ability to place a septic system in certain areas. So that's the reason for the 180 feet versus 100 feet. So at this point, staff recommends that the Planning Commission approve use permit 1115-15 based on the required findings and CEQA findings and the subject to the conditions, recommended conditions of approval. You have site plans and maps in your packet, and we do have,
Change that, but we should change this. I talked to Public Works today.
we're requesting an amendment of condition number 15, the first bullet point to strike the statement "or as otherwise determined by applicant's engineer."
Say that change again, Byron?
Strike where the parenthetical "or is otherwise determined by the applicant's engineer."
Just delete that.
Yep.
Okay.
Okay, we open public comment. Anybody from the public? Nobody? Okay. Public comment closed. Commissioners?
I do have one
Question.
question. Byron, is there some kind of a rule about how long the feeder line can be from the septic tank to the leach field? Because it seems like you could locate the leach field where it needs to be and still put the house elsewhere.
You know, this was reviewed by the Department of Environmental Health. They make those determinations about distance to the floodplain versus, and soil types and such. This was reviewed by them, and the application was, I mean, I don't know, but I assume that they did some research as far as location of the structure, and because the reason in the application for moving was that they did not want to have to put a septic system in the floodplain. So I cannot answer that question except for letting you know that Environmental Health, who would issue the septic permit, has reviewed the application.
Okay.
Mr. Chair.
Commissioner,
On the senior units, what is the maximum square footage on a senior unit?
1,050 square feet. Unless it's handicap accessible, then it can be 1,200 square feet.
Thank you.
And you may have addressed this, Byron, in your introductory remarks, but I was in building and planning, and I think Michael Krause explained to me the reason for, we don't just grant these all the time, but only under specific circumstances where topography or distance or something warrants that. Did you explain why that's
Yes,
true in this case?
Yeah, and that would be the floodplain. The reason why this is coming to the Planning Commission, and the reason why we're recommending approval, is that it's not practical to put it within 100 feet.
Right, but if someone comes in and says, I want it to be further just because I want to, then that wouldn't be appropriate.
That wouldn't be something that we would necessarily recommend approval.
Okay.
We would, it's not about cost, it's not about money, it's not about, how they want it designed. There's a reason why we want things within 100 feet, but there's also reasons why to deviate from that, and this is one of them.
Okay, very good.
any more questions? Do we have a motion here?
Okay, I move that we approve use permit 1115-15 based on the following required findings and subject to the recommended conditions found in the staff report with the staff changes.
Second.
All in favor?
Aye.
Aye.
Question on this next one. Did you get
Next item.
15
Good.
The applicant for Hospital Road. 4, 5, and 6 are joined together.
Did you want to change this one, these two?
Who's that? Who's doing that one? Michael?
Do we have a new one handy?
Yeah, this one, the last one we did.
Okay.
And then who is responsible for reporting the certificate of compliance? Should it be applicant shall record, or is the county going to record?
The applicant records.
So should we say applicant shall record the certificate of compliance? Okay, shall be recorded by applicant.
Yeah, yeah. But we give
And
the
I can just
information.
read the new home.
Okay.
home
Good.
cost.
Thank you. Yes, this is for certificate of compliance, number 14-89 and 14-90. We've lumped them in as one. The applicant is requesting that the county determine the number of legal parcels that comprise approximately 26 acres, identified by 3 assessor's parcel numbers that are listed in your staff report. The location of the parcels is on Hospital Road, adjacent to the San Bernardino River. The certificate of compliance relates only to issues of compliance or non-compliance with the subdivision map act and local ordinances enacted. The parcel described, should the planning commission approve, the parcels therefore may be sold, leased, or financed without further compliance of the subdivision map act or any other local ordinances that may apply. But development of the parcel may require issuance of permits or other grants of approval. The information that was provided through the deeds provided by the applicant and the research done by the planning staff has determined that the parcels included in this application were lawfully created, and therefore staff recommends that the Planning Commission find that the project is categorically exempt from the California Environmental Quality Act pursuant to Section 1561B3 and Section 15305, and approve the certificates of compliance with the recommended conditions.
As far as the recommended conditions, I would like to make a change. As far as the indemnification condition, I'd like it to use our new format. I'm going to read it into the record. It was in our last agenda item. Applicant shall defend, indemnify, and hold San Benito County, its agents, officers, and/or employees hereafter county free and harmless from any and all suits, fees, claims, demands, causes of action, proceedings hereinactively collectively referred to as legal action, costs, losses, damages, liabilities, and expenses, including, but not limited to, an award of attorney's fees, expert witness fees, and court costs incurred by county arising directly or indirectly or resulting from the review, processing, consideration, or approval of applicant's project or action taken by county thereon, including legal actions based upon the negligence of county. Applicant will reimburse county for any damages, costs, or fees awarded pursuant to any settlement, default judgment, or any other judgment taken against the county, whether the result of applicant's decision not to defend legal action or otherwise. County retains its discretion to direct counsel regarding whether to defend, settle, appeal, or take other action regarding any legal action. And also,
That sounds scary, but it's our standard
it's our-
hold harmless
it's-
language.
It's our new standard hold harmless language.
You're all out of the long ones?
Pardon?
No, I'm just
The
kidding.
more words, the better, right?
So that would just, before you go on, Barbara, that would replace condition of approval number 1 under hold harmless, correct?
Yes,
Okay, so delete this and insert that.
yes.
Okay.
And also, on number 2, the certificates of compliance shall be recorded, and then insert the words by applicant with the county recorder. That just indicates that they're responsible for recording the certificate of compliance, rather than the county being responsible for recording those. And that's it. Thank you.
And you'll get your new language to whomever it needs to get to? All right. 'Cause I don't think we wrote it down.
Yeah, it's the same one that was in our last staff report. It's our standard language now.
Okay.
Okay, we open public comment. Anybody to speak on that part?
Yes, it was the reason why I came this evening is, Valerie Egeland, Reach, Parks and Rec, stuff. The parcels in question seem to be near the river, since they are with the floodplain. And so I'm wondering, is there any consideration that should be made about the parcel division that would affect the future plans for the River Parkway and the Parks and Rec development for San Benito County? And is there any reason why that should be considered at this point? And since I don't know that, but I see this is within the floodplain and at near Hospital Road, where it's going to be a critical on-off into the River Parkway, and that it will be developed. So I'm just questioning that publicly.
Thank you. Any questions?
Well, the certificate of compliance, I think, first of all, let me say, we should all be keeping the River Parkway in mind when we deal with projects that are down by the river here, and it is an important long-term project for the county. But in this case, the action before the commission is simply recognizing the legal status of the parcels, so there's really no nexus for requiring anything at this point, although I think it serves everyone well that the owner, property owner, is aware that the River Parkway is something that is nearing his property and should think about in the future.
Well, and that said, it's a volunteer program. So the River Parkway would have to go to the landowner and say, we want you to cooperate, and if they agree to cooperate, otherwise they're not obligated. That's my understanding of that when we wrote it. Because we don't want to take, so it's a matter of just cooperation. And then it would probably only be that trailway. So I don't see that that really affects it that much. I don't think there's that much to worry about with it. Okay?
Any other speakers? Okay, close public comment. Commissioners, any more questions? No? Do we have a motion?
I'll make a motion. I find that, I move that we find the project categorically exempt from California Environmental Quality Act pursuant to Section 15061B3 and approve certificates of compliance 14-89 and 14-90 with the recommended conditions and the changes recommended by staff.
I second that.
Noting the fact that we're also finding exempt pursuant to 15305.
Yes.
Yeah, you said that.
Thank you.
And I second it.
All in favor?
Aye.
Aye. The next one. Another cell tower.
This next item, use permit 1118-15, the applicant is proposing a new Verizon wireless facility, including a new 80-foot tall faux water tower with 12 panel antennas and associated equipment. The subject parcel is a 56-acre parcel zoned ag productive, located approximately 1,000 feet west of Fairview Road, north of McCloskey Road. Access to the site is gained through an easement. There are no homes within 500 feet of the proposed tower site. The site is generally flat, with primarily agricultural uses located on the property. The applicant has submitted visual representations of the wireless facility. They are within your packet. I did not, given our history with trying to get them to project, I didn't bother. So I thought that hopefully the visual representations that you have will suffice. Michael, if you could move to the next slide. I do have one, and you have this in your packet, but showing the schematic of the water tower. No suitable co-location sites were found, therefore this new site is necessary for the network. Co-location of telecommunication facilities is allowed by the county, and we do have a condition requiring such. There are also no schools within 1,500 feet or homes within 500 feet of the project site. The tower is designed to potentially accommodate future co-location. Just one amendment on condition 12. It refers to a monopole. This is the co-location condition. This is not a monopole. I would replace monopole with existing facility. Or facility, actually, not even, because it's not existing yet. And that condition does incorporate that all future wireless carriers incorporate stealth design, as the commission has directed in the past. There's a CEQA finding, section 15303, that needs to be made, as well as the use permit findings. So staff has reviewed the proposal and can find no objection to the proposed request on the project site. Staff recommends that the planning commission approve the use permit, find the use permit, the project exempt from CEQA pursuant to section 15303, and approve use permit 1118-15 with the CEQA finding and the conditions of approval and the required findings. I'm available for questions, and the representative of the tower is here as well.
Okay, public comments open. No one wishes to speak? Those, any questions?
She's like, I don't want to if I don't have to.
No, it's,
What color is it going to be?
Tan.
Yeah,
yeah.
because you got to use the microphone.
I'm happy to kind of give an intro or just answer questions, but the facility will be a tan color. My name is Jenny Blocker, on behalf of Verizon Wireless.
Any other questions?
No, I mean, I like the, I love the water tower idea, because a lot of these environments, you put a big old pine tree out in the middle of the field, it looks almost as out of place as a more industrial type cell tower. So I think water tower fits the vernacular of the countryside better.
Agree. It seems to make more sense, yeah.
You know-
By the way, when you go back to Verizon, windmills, water towers, and these farming kind of things, you know, when trees just seem out of place.
Sure, it's much more compatible. Also, the nice thing about the water tower is that all the equipment is completely concealed behind FRP material that allows the antennas to shoot through it, but all the equipment is fully enclosed in the water tower portion. So it is a great design, and I'll let them know.
But it should have a sign that says no swimming.
Yeah, or John Deere. Mail pouch tobacco.
So, I got a question. You guys have planned to change it when the city grows around it?
When the city girls are on it?
Yep, city's going that way.
The city grows.
City grows. Oh, I'm sorry. So changing it in what way? Just modifying the equipment?
Looks.
Oh, the looks of it? No, we don't have any current plans to. Right now, it's kind of compatible with what's existing on the parcel.
Nope, no more questions.
Okay. Public comments close.
Okay, thank you.
Okay. Any other questions, commissioners? Do we hear a motion?
I'd move to approve this agenda item with the recommendations of staff, including the modifications to condition 12 regarding monopole and existing facility and so forth, as articulated by the director. Are you still the director of planning? What's your title? Byron Turner, Mr. Turner.
I believe this is an item that's going to be discussed at the board on next Tuesday.
This?
The organization of the.
Oh, your title.
Of the
Okay.
Resource Management Agency and titles.
This water
yeah.
tower is going to the board? Okay,
Second.
That includes the finding for the 15303.
correct.
Second. Okay. Everybody in favor?
Aye.
Aye.
Okay. Next item, I think everybody's anxious. Adjourn. Do we have any questions for staff? Or?
Let them know.
I just have one question. Hey, Byron, I know that the 500 feet been kicked around. When is that going to be removed or brought to the planning commission to be removed?
For cell
We'll
towers?
be,
Yeah.
we'll be looking at that after the general plan is, assuming it's approved. Then the next step will be making all of our ordinances consistent with the new general plan, implementation of the general plan. So that's when we will take that one as well as all our other, whether it's zoning or the wireless communications grading ordinance, anyone that we need to back through the planning commission. We'll be having, the work of the planning commission is going to be beginning now with regard to how we implement the general plan. So we're going to start having workshops about what the general plan now says, and then what ordinance changes we need to do to make our ordinances then consistent with the general plan.
Zoning?
Like zoning, yes, and like scenic highways. And wireless communication is one of those ones where we know we need to make changes, and so we'll be bringing those forward along with a bunch of others, so.
Can I update the planning, I'm sorry.
No.
I just want to let the planning commission know that there is the litigation now regarding the Pinoche Valley approval. We recently had a settlement conference. It did not, there wasn't really fruitful, so it's going forward, and that's all I can report at this point in time.
What's
just in
the
case-
title of the litigation?
Pardon?
How's the litigation captioned?
Sierra Club, and it's Audubon Society versus County of San Benito. I think it's the Board of Supervisors. Is that the question?
Yeah, so the petitioners are
Or Sierra Club and,
Audubon?
Audubon.
Only?
yes.
Not so the Save Pinoche Valley folks
No.
dropped out?
No, yeah. And also, Adams Broadwell is now totally out of the picture. The union, the firm that was representing the unions, that they didn't join the appeal.
So it's just Sierra Club Audubon versus the county? Interesting.
Now, do we
Byron,
have
what's top of pile on the ordinance changes and stuff that we might be doing? What's top of pile? What's the low-hanging fruit?
Well, I think that the wireless communication one is one that's an easy one, and also the, anything to do with water are important ones that we've been wanting to get to as well. But the zoning ordinance has to happen right away, too.
Yeah. Do we have to update the park master plan to have it mesh in?
A what, Ray? What'd you say?
The parks master plan. It was done like, I don't know, 7 years ago, so it could mesh into the general plan.
Right.
And everything's changed.
If it references policies from the old general plan, then yeah.
Yeah.
I have another question, Byron.
Nobody wants
And it wasn't quite answered from Public Works the other day. They cut down some beautiful trees on Vets Park. What was the reason behind it?
That's city, isn't it?
No, it's county.
It's a county park.
It's a county park.
Yeah. City sure.
There were some beautiful trees there that got cut down.
Oh, it was on the verge of falling, or the branches were
I don't know.
causing
That's
a hazardous condition. I've heard that few of the branches actually fell on some of the visitors down there, and they put a claim to the county. So we looked at the situation, and I think that's
But there was
from discussing.
no maintenance on them, like trimming the dead wood out of there? Or?
You know, I need to get the information back from our park maintenance guy, see exactly what the reason was, or is there any other compelling reason, like, you know,
So-
disease or whatever,
Shakespeare
that could cause the branch to fall off, you know, on check.
Because now that people want a pole there so they can hang their piñatas. So we have a motion to adjourn?
I believe she's made it 3 times.
3 times? Second?
All in favor?
All?
Aye.
Good.